Hello and welcome to the big picture. The Supreme Court judgment on Tuesday allowing restrictions on media reporting of cases under trial has set off a major debate in the country. The order, which came on a petition filed by the Sahara Group, though has refrained from formulating guidelines for legal reporting, has evoked mixed reactions, with many expressing serious concern over postponement of reporting as an unreasonable restriction on the freedom of the press. There are also voices in support of the Apex Court order, which sees it as a reasonable restriction in the interest of free trial, as expounded in the Constitution. However, concerns are being expressed that this judgment of the Apex Court will be only beneficial to the rich and can also be utilized to keep the truth away from public glare. Another issue which has cropped up is, in this age of internet and social media and increasing demand for free speech, whether such restrictions would be practical and implementable at all. The 5-judge bench order is bound to raise more hackles and provoke more discussion in the coming days. Today, we will look at all the issues raised by this judgment while asking the question whether the Supreme Court has rightly imposed the restriction on the media or not. To discuss this, I have with me eminent Supreme Court Advocate Raju Ramachandran, former Chief Justice of the Punjab and Haryana High Court, Justice Mukul Mudgal, and Managing Editor of Tehelka magazine, Shoma Chaudhary. Welcome to all of you. Let me first go to Mr. Raju Ramachandran. Raju, the Supreme Court's argument is that they had to balance between free trial and freedom of speech and expression and the rights of the media. Does this really balance it?
Girish, my first problem with this judgment is that there was no occasion for the Supreme Court to go into this question at all. It was a completely unnecessary and, if I may say so, a completely gratuitous exercise.
The Sahara Group routinely filed an application.
Sahara Group complained about the leak to a TV channel about a compromise proposal in a pending litigation with SEBI.
Yes.
Now, when that grievance was made before the court observed in its order that it was very distressing.
Absolutely.
Then the court makes a suggestion to both parties in that case, that is Sahara and SEBI, that they could make applications so that guidelines could be laid down, because this is becoming a very frequent occurrence.
Neither the petitioner nor SEBI had made any such demands.
That's right. The complaint of Sahara was about the leak of that particular compromise proposal, nothing more than that.
Absolutely.
Therefore, the first point which I wish to make is that this is a completely unnecessary exercise, and I think this has been a waste of precious judicial time.
17 days.
Absolutely. Now, the Supreme Court has advisory jurisdiction under Article 143 of the Constitution, and the President wants the advice of the Supreme Court. There is no other jurisdiction in the Supreme Court to proffer advice ex cathedra, to give ex cathedra observations, because the Supreme Court feels strongly about something. Now it has undertaken this exercise. It reiterates well-settled principles, but then goes further and lays down some startling propositions, which I am sure the distinguished former Chief Justice will enlighten you on. But it was again, as I say, totally unnecessary and would now only give ideas to the rich and powerful to seek gag orders. Such an occasion could have arisen in a given case. This was not that case.
Okay. Justice Mudgal. Raju has, basically he questioned the entire reason for them to even hear this matter like this. But the Supreme Court says that, this is something which was happening too often. We need to go into this. So actually they started off saying that we will formulate guidelines, but they have refrained from doing that. And they say that this postponement of the
reporting
is a reasonable one, because they are balancing this, the right of free trial with the freedom of expression and freedom of speech and the media's rights. Do you agree with Raju Ramachandran on this? Do you think the Supreme Court went beyond its jurisdiction?
I wouldn't like to comment on that, but I'd like to say certain things, and I agree with Raju on most of the things he said. One is, the entire discussion in this judgment relates to criminal trials.
Right.
Right? Now,
but it is it's ironical that the matter was not a criminal one.
No, it was not a criminal one. I'm coming to something else.
Yes.
It relates to a criminal trial. It gives the right to accused to go to the writ court and seek orders. Now, accused in incarceration, some poor accused who's being hit by publicity, to expect him to go to a writ court and seek writ orders doesn't mean it's not going to be possible for a weak and an uninfluenced person to get these orders. Secondly, you will be surprised that while it originated from a so-called civil dispute, this was, incidentally, the leakage was of a letter from the Council of Sahara to the Council of SEBI. So
it was not a leak, they passed it on. It was a proposal.
So the real inquiry should have been, which of you have passed it on, if at all? That inquiry is not done.
Both of them accused each other.
Secondly, IAs filed by the applications filed by Sahara and SEBI are disposed of with the directions, and many accused files applications, they are all dismissed.
Yes.
They could have been kept pending and asked them to go to the various courts,
right.
High Court or Supreme Court, as the case may be. So, and the other thing is, a very perplexing postponement order prevents such measure. The principle laid down is these postponement orders prevent the media from being prosecuted from contempt.
Exactly.
Now,
they say that we are going to prevent media from getting
prosecuted. That's the risk an independent media takes. So
Absolutely.
I don't think, this postponement order is not a principle which is found anywhere. And secondly, I on principle am opposed to relying too much on foreign jurisprudence, because I have yet to come across a US judgment which quotes an Indian judgment. Then why are we getting...
No, but this judgment seems to have, if I'm not wrong, both of you can correct me, they're relying on a 1981 Human Rights Act of England. England's, they're relying on that, and they're saying that in England there is such restriction has been imposed, so we can also impose it.
To be fair to the Constitution bench, they are relied on the Indian law also.
Yes.
But the neutralizing device is traced from American jurisprudence. Right. And postponement order principle, I've already said, I don't agree with this.
Okay. Shoma, the two legal luminaries are on my panel in the studio have put forth their case very, very, very forcefully. Now let us not look into the legalities. I want you to think and talk about what do you think will be the impact of this judgment?
Girish, I think that this is an extremely, extremely disturbing judgment and ruling. I think it sets up a very bad precedent. It sets up a very bad atmosphere, where I feel that there already was possibility of recourse. It's undeniable that the media sometimes is egregious in the way it covers ongoing cases, and the Arushi Talwar case is a perfect example of that. But it's much better to deal with the exception than to make it normative. There was already a possibility of recourse if the media oversteps what Justice Kapadia has called the Lakshman Rekha.
Right.
But I think that this is going to curb media freedom in extremely dangerous ways. And I'd like to make a couple of points, which is, in this whole debate about right to freedom of speech versus the right to a fair trial,
right.
I find there to be a deep irony, because one would assume that a media story can sway public opinion. But a judge should surely be immune from prejudice, and just look at the facts of the case before him or her in his court.
Absolutely.
If we grant that a judge is fallible and human, and so prone to making errors of judgment, or is susceptible to public opinion, or susceptible to prejudice, then how are we to assume that the same judge can assess whether a journalistic story is worth carrying at that very moment or should be postponed. So I find it extremely problematic. Girish, if I may just finish making this point.
Yes. Okay, continue.
I said I also find it problematic that, any High Court judge, any Supreme Court judge can decide on these matters, because then the whole idea of media freedom, which is a very basic plinth of democracy, becomes susceptible to the individual judgments of people.
Right.
Now, the judiciary as an institution is something that we respect, but historically and evidence shows us that individual judges can make extremely fallible assessments, And I'll give you an example of Tehelka's own journalism, whether it's in the Binayak Sen case, where we examined the prosecution's evidence, analyzed the prosecution's case and the evidence against Binayak Sen, on the Soni Sori case, on, Jessica Lal's murder, which Tehelka's investigation helped actually reopen that case. Look at the Tehelka sting investigation into the Gujarat riots of 2002.
Absolutely.
Would we really want an aggrieved party to go to a High Court judge and postpone the publication of a story like that just because, many vested interests could come into play?
Absolutely.
So I would stoutly defend the right to freedom of expression and the freedom of the media, and rely on recourse on case by case when the media oversteps the line, rather than the other way around.
Which is how it is at this point of time. Anyway, Shoma, one more thing which I was trying to point out at that point of time, Mr. Raju, to Shoma, was that this judgment doesn't talk about how the judges are going to be influenced. It's talking about how the accused is going to get victimized by this reporting.
Absolutely.
Right?
When we are talking of the right to fair trial being impinged upon,
right,
what we need to see is the judiciary going to be influenced?
Yes.
That point seems to have been completely missed.
That has been completely missed in this.
Absolutely.
And the order is talking about how the accused can become victims and how the accused's right to fair trial needs to be protected.
That right to fair trial is affected only if the judicial decision-making process is perverted.
Absolutely.
If you have a strong and independent judiciary, it will not be swayed by what is written in the media one way or the other. They'll apply their minds independently.
Absolutely. Anyway, we will go into a short break now. When we come back, we'll look at some of the cases which the Supreme Court seems to have been influenced by while passing this order. Some of these cases we'll mention, and we'll continue this discussion. Please keep watching. We'll be back very soon. Welcome back. We are discussing the Supreme Court order of yesterday's giving rights to the accused to get the reporting of the trial postponed, and asking the question whether it's a reasonable restriction. Justice Mudgal, one of the things which is there in the judgment is it says the right to negotiate and settle in confidence is a right of a citizen and has been equated to a right of the accused to defend himself in a criminal trial.
I think this is no source is quoted for this.
No source is quoted
because the word used has been.
Yes.
Has been denotes that it had earlier been decided, or there is a literature on this. But probably this is this judgment. But I think one thing you ought to notice is it says a citizen, and it is very difficult to call Sahara or Sebi a citizen. They can be persons.
Right.
Legal persons, but they can't be citizens.
Right.
That, and secondly, I don't see any jurisprudential basis for this. Secondly, you see, what is most difficult is the generality saying it depends on the facts and circumstances of each case.
Each case. Case by case basis it will be
Therefore,
decided.
what have you laid down? Except postponement principle, neutralizing device,
right,
you have not laid down anything new.
Right.
The law of contempt
and
in camera proceedings protects all that.
Absolutely. Raju Ram, this is the question which I want to know. There is already a provision for in-camera proceedings. Was there a need for this?
Absolutely not. There's a provision for in-camera proceeding.
Right.
There is a provision for contempt. If a particular news report tends to interfere, then you could have taken contempt proceedings.
It's very interesting. The judgment says that they're trying to postponement will prevent contempt, and
the media needs to be saved from itself. I don't think the media needed the court's protection.
Right. So anyway, coming to this point which I was asking earlier, the judgment says that we will impose this restriction, and it's a reasonable restriction. Some who are in favor of this says that a Lakshman Rekha needed to be drawn for the media, and the Supreme Court through this order has drawn the Lakshman Rekha. Have they really drawn the Lakshman Rekha?
No, the Lakshman Rekha is the Contempt of Courts Act.
Exactly.
This judgment was not required.
Right.
If someone crossed that Lakshman Rekha, then surely in a given case, the court could have invoked the contempt power and made an example of that particular case,
right,
because it really interfered with the course of justice.
Right.
We don't have such a situation here.
No, there were so many criminal accused persons had filed in application before the court. They have all been dismissed. None of the facts have been discussed. And those criminal ones have been dismissed. The civil ones have been disposed of. And based on the...
No, it's very ironical that in this case, the final decision of the Supreme Court went against Sahara Group, finally.
Absolutely. And also neither Sahara nor SEBI have been conspicuous for their work in the field of criminal jurisprudence.
No, the only Lakshman Rekha, according to me, which could have been drawn, is you see every day an accused is arrested and the police is making him blurt out that, yes, I killed the man like this.
Yes.
Now, the court could have issued directions to the state and said that these kind of exposures, this finishes the test identification parade.
Absolutely.
Secondly, a magistrate who has seen this man confessing in TV, is going to be very difficult for him to acquit such a person if the police has forced him to confess. So on this, if the court had given guidelines, because...
But in this case, those matters
have not even been considered.
Not have come up at all.
No, those
in any case. Anyway, Raju, what I want to know is, now they are saying that from case to case basis, you will have to decide. Now, what will be the implication of this on the judicial system itself?
The implication of this, as I see it, is an already overburdened judicial system will now be dealing with cases instituted by a rich, powerful, celebrity accused seeking gag orders.
Right.
It is only going to burden the judicial system further.
Okay. Shoma, coming back to you, some of the cases which have been mentioned as having breach all the limits, because of which there has been problems for the accused or even the victims or what is one of these is the Radia tapes. The publication of Radia tapes is considered. See, look at Radia. Neera Radia has managed to get a stay. Amar Singh had managed to get a stay. Who are the people who have managed to get a stay on these kind of things in the past? And now, don't you think this order will now encourage more and more such people to go to the courts and stop us from discussing or writing about it?
No, absolutely, Girish. I've already spelled out that I think this is an extremely, very, very worrying judgment, because yes, it adds to the discretionary power of judges in a way that is not really laid out as your esteemed panelists have already been saying, that rather than stringently spell out the rationale for ruling like this, it's left it extremely open to the discretionary power of judges, to extra legal pressures. And yes, I mean, history shows us that it is the rich and the powerful who use this, and I can give you n number of examples where it is in fact the intervention of the media that has helped bring justice, or it has helped expose facts, For instance, the Malegaon victims, where very innocent Muslim boys were put away for 8-9 years. It is again journalistic intervention, journalistic work that has helped bring facts to the surface. And we must remember that the media is one face of democracy as much as the judiciary, the executive and the legislative is, you know. So I feel that when we are talking about Lakshman Rekhas, there are individual judges that cross the Lakshman Rekha of judicial transparency, judicial accountability, judicial respect, you know. And are we now going to curb the judiciary's capacity to do its job just because it has some black sheep within its fold? In the same way, when the media makes mistakes, there are already corrective measures. There are social pressures, there's recourse, there's defamation, there's contempt. You know, there are in-camera proceedings. There was absolutely no need to have this kind of, you know, gratuitous, as Raju just said, gratuitous advice or even frameworks to be put out. This is going to be very, very badly misused.
Shoma.
And Justice Kapadia himself said a very important thing a few days ago when he said that judges should not put out rulings that are not implementable, because in a way that ends up being disrespect of the courts. And I can tell you in advance that this is something that will not be implementable. Every self-respecting media house will flout this norm, and one will court contempt then, because this cannot restrict you from your professional duties.
No,
so I
Shoma,
think that the judges have put out a judgment that from the onset is going to be flouted.
Shoma, my curiosity is this. They have said that case-to-case basis they will decide. Now, you know, a magazine or a magazine like yours or a newspaper, daily newspapers, how is it that we are going to decide, or how do we decide on a day-to-day basis whether this should be covered or not covered? And, you know, once the application goes before the judge, then whether we have to stop publishing anything anymore till a decision is taken. I mean, this whole thing looks, I'm wondering how the media will be able to tackle this issue at all.
No, I think it's a mind-boggling thing. You know, it's very much in keeping with this climate of censorship and narrowing down of trust on which a society must operate. You know, when you speak of Lakshman Rekha in the practice of media or any profession, it has to rely on the editorial integrity of editors. You know, I mean, there is a colossally bureaucratic process of, you know, first media deciding whether a case really deserves to be reported on, then it going to a judge using extremely discretionary power to decide whether a media story is worth it or not. That was never put up to him in the first place. Absolutely. You know, why should it come under jurisprudence in the first place? This is an absolute overstepping of very well demarcated principles on which a democracy is founded, you know.
Yeah.
I think it's an extremely faulty judgment, and I want to reiterate that it will be flouted. I mean, from any self-respecting media house will flout it. No. So how many people are you going to haul up for contempt?
Absolutely. Raju, you know, apart from what Shoma is saying, that, you know, any self-respecting media house will flout this. But there's also the social media now. How are you going to stop the social media from, or the internet?
Absolutely.
If I have a website, you know, which is my private website, how are you going to monitor these hundreds and thousands of websites where anything can be published?
Don't we have a recent example of a prominent political figure getting a gag order?
Sorry?
Getting a gag order from the Delhi High Court on a personal matter.
Absolutely.
But the same matter going wild on the internet.
Absolutely.
That's the answer. It's not possible.
So, Justice Mudgal, they say that under an article, the judgment talks about under Article 141. There are criticisms now. Some people have criticized that this is almost akin to a constitutional amendment. But the Supreme Court order is saying that under Article 141, we have this law-making exposition of constitutional limitations.
No, the Supreme Court, you see, the 141 is provided for extraordinary situations where there are loopholes in the law and the interest of justice requires it.
Right.
If some criminal case had been discussed where gross injustice had been demonstrated by exposure.
Let me get a clarification. This order, if it is implemented, if it is taken seriously by everybody and whoever, it is applicable to both the civil and criminal cases?
Well, it is.
Yes, it is.
It is, but it is based, it is, this where the dichotomy comes. Starts on a confidential letter between two counsel. Their role is not, only one of them could have leaked it.
Yes.
That's part. The second is, it does not discuss any of the applications filed. It could have taken up a glaring case and said that this facts of this case demonstrate. On the contrary, all the application of the accused have been dismissed.
Absolutely. Raju, last words to you. What is the, how do we overcome this problem? Is there some relief? Is there any way in which this order can be, anybody can go back to the court and say that please look at this order again?
A review petition can always be filed,
yes.
But this is not the kind of case where the Supreme Court is likely to review its order, and so soon. When a case comes on that case-to-case basis, and this case is cited, then it is possible someone appeals to the intelligence of a future day, and that bench doubts the correctness of this judgment, and the case goes to a larger bench. This view could be reversed.
Okay. With that, I think we have completely run out of time. It's very interesting that today's discussion makes it evident that sometimes even the apex court can come out with judgments which can be questioned seriously, and also the more important thing is whether it can be implemented. As Shoma Chaudhary pointed out, what the Chief Justice of India recently said seems in this judgment he seems to have forgotten his own words. Anyway, this is something which we will keep watching, because as some of my guests here talking about, the judiciary in this country may get, a flood of such writ petitions may come up before the judges, and we will see how it will be tackled. Anyway, this has been an interesting discussion. We'll keep a close watch on how it will be implemented in the coming days. Thanks to all my guests, Shoma Chaudhary, Raju Ramachandran, Justice Mudgal. Please keep watching. We'll come back with another issue on The Big Picture, same time tomorrow.